Howdy and welcome to the show. Cooper's Code focuses on legal issues and notable practitioners, distilling wisdom so we will all achieve the best results for our clients. I'm Miles Cooper, and with today's guest, Lorie Nachlis, a certified family law specialist and a fellow of the American Academy of Matrimonial Lawyers, we'll be exploring family law. Why do we want to know about family law? Because our clients are humans. Humans have families, and families sometimes have friction. We want to be able to issue spot for our clients, and when appropriate, make sure they get help from someone like Lorie. So who is Lorie Nachlis? She's a practitioner with 4 decades of experience as a litigator and mediator. Early in her career, she did jury trial work in federal and state court before shifting her full attention to family law. She also mediated between the parents of special education students and school districts throughout the state. The combined insight on jury work and mediation gave her the launchpad to explore creative resolution concepts with the ability to pivot into litigation when necessary. Lorie's subject matter mastery got her a direct appointment by the former Chief Justice of the California Supreme Court to the Elkins Task Force, where Lorie and others revised and improved family law policy and procedure. Lorie was named Fellow of the Year by the Northern California chapter of the American Academy of Matrimonial Lawyers, named one of the top 2 Bay Area family law lawyers by the San Francisco Recorder, and received the Award of Merit from the San Francisco Bar Association. In between all of this, Lorie has been a successful parent, grandparent, and scuba diver. So please enjoy this deep dive into family law with Lorie Nachlis. If you're enjoying what we're doing here with Cooper's Code, please extend our reach by giving us a 5-star review on Apple Podcasts and consider sharing an episode with a friend. Welcome to the show, Lorie.
Thank you very much. I'm happy to be here.
Can you help us understand a little bit about your background in terms of what brought you into the law in the first place?
I finished college with my teaching credentials. I was ambivalent about going to law school. It was a time that teaching jobs were very hard to come by, as opposed to now. And I got a job typing 8 hours a day with a dictaphone on my ears. And law school looked pretty good to me after that experience.
Law school brought you out to the West Coast?
I did my first year of law school in Pennsylvania. And it's actually kind of a funny story. My grandmother left me $2,000. I was a single parent and decided to take that $2,000 and spend a summer in San Francisco. My brother lived in Los Angeles, but I would need a car there. And the idea of San Francisco was just fabulous idea. And but being the daughter of my parents and grandparents, I couldn't just come for a summer of fun. I took 2 classes at Hastings, now University of California. And not only did I take 2 classes there, but when at the time in Pennsylvania, I was clerking at a law firm where one of the partners just thought that I should be home with my child, not working, not going to school. And I came to San Francisco, and Hastings had a child care center. And so I took the classes, had a wonderful summer. And by the end of the summer, I made a decision that if I had to start law school all over again, I would. I was not going back. And fortunately, I got accepted and graduated from Hastings.
In order to help us understand kind of the time period, because some of the things you're talking about, typing, teaching jobs, a partner saying you should be home with your child, approximately what years was this?
Well, I moved here in 1978. And I was just telling my son the other day that when I was finishing law school and looking at the placement center and looking at jobs, I was told not to put on my resume that I had a child and keep that as secret as I possibly could. And I made a decision at that time that I would not apply for a job where I had to hide that I had a child. So I ended up opening my own office on 24th Street. And fortunately, you mentioned that I was mediating for the state, and fortunately, I got a job or a contract with the State Department of Education to mediate special ed disputes between the parents of special ed kids in school districts throughout the state. So I had that for some income 2 to 3 days a week, and I opened up a neighborhood practice.
By neighborhood practice, can you help us understand a little bit more what that might mean?
Pretty much people in the neighborhood who got to know me and had a case, if it was regarding a commercial lease on 24th Street. I became a self-taught expert in commercial leases, and there was a period of time where I had done a lot of the commercial leases. I had somebody who was a friend of the family who was doing some work with a corporation in Palo Alto, and eventually I began to do all of their employment work. I had a professor from law school who ran a clinical program at the University of the Pacific. He's taught at UC in pharmacy, and he sent me a decent amount of work from people he knew who were professors at the university, former students of his, and so I began to do divorce work as well. My son was in school and parents got divorced. And that's what the neighborhood practice was. And I had, Noe Valley was, there's Starbucks on the corner of Noe and 24th right now. And my first office was upstairs.
Oh, wow.
Yeah. That was my neighborhood practice.
Mediation seems, from the civil litigation side, the personal injury work, commercial work that I'm more familiar with, it seems like mediation really didn't start picking up speed until the 90s, early 90s-ish, in terms of when I think JAMS was one of the first organizations started. I'm curious how this school district, the California schools, ended up doing a mediation practice so early on in the process.
It was brand new. When I was in my last year of school, I had an internship at Public Advocates, and the lawsuit I was working on was there were contract negotiations broke down between the school districts and the teachers union. And it was at the beginning of school, and nobody was talking. And so I worked on a lawsuit that was on behalf of the students of San Francisco to try to get an order to force the two sides to talk. And the part that I worked on was really in demonstrating the regression among special ed students by not having their needs met. And at the time that I was doing that, the state was considering mediation. And you're right, it was brand new at the time. There are the federal laws that require that the students get an individualized education program. And by the federal law, you had a fair hearing process in California, being California, at least at the time, decided to put a first step in the process of mediation. And so we had a training. I'm not sure about jams because I kind of think that this person who did the training was somehow related to jams, which was more arbitration at the time. And it was the kind of the Kissinger go back and forth between two rooms and negotiated deal. That's how we were trained, but over the years it changed. I had the first Yellow Page ad for mediation, but they made a mistake and put it under meditation instruction.
That seems so fitting and something that spell-check would hopefully correct at this point.
Exactly, and I had I negotiated with, I think it was Lawyers Mutual, I don't remember, to get, I had the first malpractice policy because they wouldn't issue me a malpractice policy for the other work I was doing unless it covered my mediation work. So that's my beginning of mediation.
Complete tangent or rabbit hole, but did you get a refund from the Yellow Pages for the year that they put it in the wrong place?
I don't remember.
The dual track, though, and I'm jumping ahead because I know from reading up on you before you came in that you did do a fair amount of jury trial work as well.
I did.
And what I'd like to do is maybe explore that a little bit so we can set the stage for what I would describe as specialized learning as being an early mediation practitioner and experienced in the courtroom and how that may have shaped your vision towards taking on cases.
I think the combination has really been provided a basis for my family law work that has been very good for me. In the jury trials, when I was in school, I was absolutely convinced that I never wanted to do a jury trial. I didn't want to be a trial attorney. I didn't know what I wanted to be, but I didn't want to be a trial attorney. I had a trial evidence seminar with Carlos Bea, who ended up on the federal court, and he would bring in these wonderful people to be judges in our trial, and I had a portion of a trial to do, and my judge was Jefferson on evidence.
That Jefferson.
That Jefferson. And we were videotaped, or however they did it at that time. And Judge Bea said to me, you're going to be a great trial attorney. And I said, oh, no, I'm never doing this. To be a trial attorney, to do what I did, I felt like I had to completely become a different person than who I am. And I don't want to do that. Well, when you open up a neighborhood practice, and I shared space with other people, you do what you need to do to support yourself and your child. And I began doing some jury trials. The last jury trial I did was 6 weeks. I had a 3-week trial in San Francisco, and by the time that I gave up jury trials, I was unsure that I wouldn't miss the idea. There's that performance end of it, that changing into that person that I resisted so much and doing that performance that has to be so well rehearsed, honed, and yet open to whatever comes your way was a very big energy boost.
I think that a lot of our listeners who have done jury trial work at some point or been exposed to it, there is an element of being in the moment when one is truly in it in jury trial work, where it's so addictive that one can't feel like there's anything better. And it is so exhausting.
Yes.
What do you think changed between the time that you were in law school and feeling like you were perhaps putting on a different personality and the point at which it sounds like you reached a point where you were comfortable in your own skin? 3-week jury trials, 6-week jury trials, that's not for slouches. What shift do you think occurred between those two periods?
Well, I think the growing up is certainly part of it, but I also remember preparing for a trial and realizing that I'm dealing with really real people, and that was so different than to do what I needed to do for this real person made a big difference from doing it in law school.
Because you had that shift one's focus.
Mm-hmm.
How long roughly were you doing jury trial work before you transitioned into more of a family-centered practice?
About 10 years.
How did that transition evolve?
I had shared office space with some wonderful people, including Donna Hitchens. And when I came back from the 6-week trial, they were counting the votes for her first election to the court. And I went into this state of, well, I don't know what I want to do. My office arrangements were going to be falling apart. And I did this program called Lawyers in Transition. It was a 6-week program that was a group. It required like some vocational tests to do. And at the end of the 6 weeks, you brainstorm. And my group thought that I should be a lecturer on cruise ships. And not being able to find any jobs like that, I was considering what it was that I wanted to do when I got a call from a family law firm, Shapiro Thorne. And I was made an offer and decided to try it. It was the first time I think I had been in practice maybe 12 years at the time. It was the first time ever working for anybody, which was an adjustment that was not exceptionally successful because I lasted there for less than 3 years, but it really did throw me into family law.
I'm finding that transition interesting because generally we are in our field, many people start from a position of safety, starting out at a firm as an associate, building up some skills and then going out on one's own. I would think it would be exceptionally challenging if you have been your own supervisor for 12 years to be in a situation where you may have to answer to other people.
Yeah, it definitely had its challenges, but I will credit Susie Thorne with having introduced me to some great people in family law and giving me a lot of leeway. Cases were my cases. And so it made the transition to full-time family work, I guess I would say. It made it work for me.
I know in the space that I've been working in personal injury work here in California, that I've seen the field change just in the couple decades that I've been in practice. I imagine you've seen some transitions from how family law was done then to how family law is done now. And if we're too early in this question, because we haven't really talked a little bit about how family law is different, you can tell me we're too early. However, are there things that you've seen change in the way in which cases are handled in the family law world from the time that you initially pivoted into being a full-time family law person to now?
Family law is, right now, you've got 75 to 80% of the litigants in the public courts are self-represented litigants. And many of the judicial officers who end up in family court don't want to be there. I chaired the family law section of the Bar Association a while ago. And I think Donna Hitchens was the supervising judge of the family law section. And I remember having a meeting and introducing the 8 members of the Unified Family Law Court and being able to say, and feeling so good about being able to say, and each one of them wants to be in family law. That doesn't happen very much. It's a very, very, very difficult assignment. It doesn't get anywhere near the resources that other departments, civil departments get, criminal departments, because of the time requirements. That's a huge change. Another huge change as a result of that is if you have a client with some money, people regularly leave the public court system and retain private judges. So there's a huge private judge practice in family law.
Why do you think that is?
There was the period of time when, boy, I've been at this for a long time. I guess Duke Majan appointed a lot of district attorneys to the court. So you had district attorneys who didn't even know civil procedure, let alone family law, sitting in the family court. And that went on for a while. But it's a hard assignment. And if I have a case that is involving, on the financial end, venture capital money and lots of assets and employment opportunities, I want a judge who knows the law and has experience. And the problem with this, what I refer to as the two-tiered system of justice, is that it's not going to get better because the experienced family law attorneys are not in the courtroom teaching the judges, and they're not in the courtroom teaching the new attorneys coming up. To me, it's a really sad situation. But if I want to represent people who can afford to pay me, and they don't want to go to the public system, I definitely make use of private judges on a regular basis.
Is that a specialty field in terms of, because we mentioned JAMS earlier in the program, and I know that there are a number of private mediation and judicial services. Is there a specialty branch, or are those types of, what would they be called, semi-judicial officers?
No, they're actually, the term I think is privately compensated temporary judge. So they are appointed by the Superior Court. The entire process is papers get filed in the public court. You're supposed to publish where hearings are taking place so that you satisfy some of the public requirements. But we have attorneys who have turned to private judging. Los Angeles recently just lost, the Los Angeles public courts just recently lost 5 or 6 really experienced family law judicial officers to the private judging field after being on the court for a long time. But what we see in San Francisco a little too frequently is a judge coming in, not wanting to be there, and gone in 2 years. And so just when you feel like I'm causing this judge to know what's going on and making some progress, they're gone. So, and then, what does that mean for the self-represented litigants? It's not a good situation.
I think your number was 75 to 85% of individuals in this 2-tier system are self-represented?
Mm-hmm. In the public court system.
Have you written or commented, done an opinion piece on this?
I did. I had a piece published in the Daily Journal about 2 weeks ago, and it followed, you mentioned earlier, my work on Elkins. And the reason I remember the first night of the Elkins Task Force. It was a 3-year project. And I said one of the reasons that I was there was I was concerned about the 2-tiered system of justice. And here I am all these years later with the same concerns. Family law is underfunded by the state, and I don't get it. If you have a personal injury trial, I assume that, let's say you have a personal injury trial that is going to take 2 weeks. You get 2 weeks with consecutive days, correct?
In a perfect world, yes.
Okay.
It depends. But I'm guessing it's not as strung out as the cases that you deal with.
No, I could do I started a trial in family law that involved, and we settled the property, involved spousal support and child custody. And we started in September, and we had our last day in January.
That's nuts.
So I may have a day here. I did a domestic violence trial that took 3 months, and I think it was something like 4 days of trial. But you get a day here, and you come back a month later, and just think of the cost. And that's why people are using private judges. Not only the cost of preparing, but you're then preparing again. You then have a judge who hasn't seen you in 3 months. So that's a serious problem.
And we'll link to the article that you wrote in terms of the 2-tiered system. Do you have a sense as to how we got here and how we can fix the problem?
Well, I was really hopeful with Elkins. It was an incredible experience. We had, I would say that about half, though I'm not sure, were judges from the trial level and the Court of Appeals. There were about 36 people, and then the other half were attorneys from public and private, as well as court administrators. And we worked so hard and came up with a unanimous recommendations. There were a lot of recommendations, which is pretty incredible. And we immediately got legislation passed. And then there was, maybe that's 2008?
I know what comes next.
Yeah. And the funding never happened. And it still hasn't happened. I think that one of the things that we talked about is presiding judges needing to understand the value of what we do in family law. And they don't. Why is it the newest person appointed to the court would be sent to family court, where people are dealing with the most important issues in their lives? But that's the philosophy that we had thought was going to change, and it didn't.
This is going to sound like it's a non sequitur. It's not intended that way. My understanding of the highest incidence of violence towards lawyers and malpractice claims are the people who are subjected to those are family law lawyers. And it is because the emotions run so high in terms of the losses that one can suffer, particularly as it relates to children. Is that
I think that's a very fair comment.
And so the reason I say it's not a non sequitur is because it appears that the element that is most fundamental to humans, families, is the one that is getting the least service through court funding and court attention, at least from what you provided.
Yes, I think that's true. I think there's a couple of organizations a few years ago that did an announcement and classified what is happening in the family courts to these families as a public health crisis.
You have used the phrase family law, not divorce lawyer, and I see you smiling. The reason I tee that up is I think in some people's minds they're the same thing. And can you explain why family law, why not divorce law?
Yeah, it's actually, people talk about dissolution. You're dissolving your marriage. Over the years, people say, so you're a divorce lawyer. Yeah, well, it doesn't begin to explain what it is that I do, because when an action for dissolution of marriage is filed in the court has jurisdiction to address the status of the marriage. That's the dissolution. The status of the marriage, the custody of the children, spousal support, division of property, could be violence, attorney's fees, and all sorts of issues relating to that. So when you talk about property divisions, well, you might be valuing a business. You might be looking at money that has been commingled for 20 years. And when I say commingled, that's mixing separate property and community property. And then there's the work of figuring out who gets what of that. It's much, much more complex. The easiest part of the process is obtaining the divorce, because we are, the grounds for a divorce are 6 months residence in the state of California, 3 months in the county, and 6 months elapsing from the date of service to the date of divorce. And the grounds are irreconcilable differences. So you want a divorce, the other side doesn't. That's an irreconcilable difference. That's the simplest part of being a family law attorney, is the divorce.
It sounds like the other pieces have lots of different challenges and require someone in your situation to either have mastery or have access to experts in a variety of areas. You mentioned venture capital. I imagine there are all sorts of different economic analyses that need to be performed when people are splitting up.
Right. I recently had a case where it was a lot of money. a lot of money here in another country. It was a 30-year marriage with a lot of things coming together in separate property, being mixed with community property, and knowing experts, working with experts is a big part of what I do. I've always been of the mind to continue learning as much as I can. I can never just turn something over to an expert. I need to understand the details of what's happening. I had a fun case, I guess about 10 years ago, in which so it's a family law case. There was a post-nuptial agreement, an agreement that the parties allegedly entered into that changed community property to separate property or separate property to community property. And the other side was made the case that it wasn't a real document, that it had been forged. And so we ended up having handwriting experts. And we also had ink, paper, and toner experts. And I focused on the chemistry of the ink, paper, and toner, and just loved the idea of, here I am, a family law attorney, and I'm studying chemistry, and I went to the lab and saw how all of the work was done, and that's can be very exciting in family law because you get exposed to things that you don't see every day.
I like that. It certainly has similarities in personal injury work, where any given case may have some nuance to it, where in order to prove your case, you're going to need to follow the evidence where it goes. The question I have, it particularly in light of what you said about courts slotting you into this slot and this slot and this slot and this slot, and cases sometimes taking 3 months. How does the presentation of this kind of information in a trial differ for the way you handle trials from kind of the general civil jury trial, since you've had that as an experience?
It doesn't. It really doesn't. Now, people say that the rules of evidence are loosely applied in family law. My favorite judges to appear before are judges who know family law, but also those who have had a fair amount of experience in civil litigation, because that's when I feel like my jury trial work really carries the day, because I understand objections, and there's a formality that, having done federal work, jury work, and state court, there was a formality that was different between those two courts, and it's certainly less so in family court in general, but depending upon the judge, I really do love that part that allows me to do what I used to do.
Is family law and I'm going to say a small practice, a small community? In the injury work that we do, I would say it's kind of a medium-sized community. They're up in the Bay Area anyway. There are people who you tend to get to know on the other side, some who you really like and say, oh good, this will be a challenging opponent, but somebody who I can actually get along with. And other people who you say, oh no, this person. How large is the family law community? Are you frequently doing work against the same narrow group of people, or is it broad?
It's a pretty small group of people. You see, there's a lot of continuing education and meetings and focus. The family law bar gives a lot of volunteer hours to the court. really a very giving group of people. And so you see some of the same people on the cases that over and over again. But, it reminds me of, this was a number of years ago, there was a colleague who was moved to a court commissioner in family law, and she died suddenly on a, not sailing, maybe kayaking accident. And that's when I made that transition to I'm okay in family law, was when I saw the way the family law community came together. I thought, these are people I could be with.
That's neat. Tell me about the American Academy of Matrimonial Lawyers. What is that organization?
It's a national organization of family law attorneys. In some states, I think in New York, it's still called matrimonial law. It's a pretty selective process to go through. It's a very long application. And in California, you have to be a certified specialist. And then there's the peer review and interview. A lot of people who've done a lot of writing and teaching and getting in the organization. I think California has always been a little ahead of the curve in states, but it's been a great opportunity for me to meet people, to talk about how they do things, to learn.
And the other, as we kind of map similarities and dissimilarities in the family law practice, usually in my world, people line up and they tend to be plaintiff side lawyers, consumer lawyers, or they're defense lawyers, people who are helping companies and insurance companies on the other side of things. Is there any sort of delineation like that in family law world where you find yourself on the same side of certain types of things, or is it just it's a separation and sometimes you're on a husband's side, sometimes you're on a wife's side? I'm not sure where I'm going with that, but I think I've given you runway to go.
Yeah, I think you have. I know that there are some firms that are men's rights attorneys.
Well, that sounds scary. What does that mean?
They only represent men, and it's an issue that it was a bigger issue in the past about fathers and child custody.
Now that I could understand.
Yeah. I mean, do I have clients that I know I will work better with than others? And that would apply to man, woman, anything.
The other piece, you may not hold yourself out this way. I know the first way you came onto my radar was I had a client who had some child custody issues. And I asked somebody I knew whose opinion I respected, who mediated in family law. And he said, oh, well, child custody, Lorie's the best person to deal with this. Do you consider that a specialty practice of yours?
I do. And I think a lot of that comes from the mediation and the school districts and reading special ed reports. I think I've always been interested in the psychological aspects. Well, I did get my degree in teaching. Children has been a big issue. But one of the things that I love about the custody work is that it's the kind of thing that I know that the work that I do makes a difference in who these children are going to become and how they're going to be, not every case, but in how they're going to be as parents. I'm convinced that happens. And I have, so the other organization that I have been very active in is called the Association of Family and Conciliation Courts, AFCC. And they've got chapters in a lot of parts of the world. It is a multidisciplinary organization that involves judges, mental health professionals, and attorneys. So I get exposed to a lot of the social science research that impacts my case. So when I'm doing custody, I have to have a client who is going to be open to hearing what the experts say about what is going to be good for your children in the future. In my retainer agreement, I actually say that you've instructed me to help create a strategy that is consistent with the best interests of your children. And that's where, so that multidisciplinary work is just something I love doing. When I was in law school and considering what I would do if I wasn't going to do court work, I actually considered tax work because I liked figuring out the numbers and playing the games with the numbers. And so I like that work as well, but I think that my practice, that I'm recognized as a custody attorney.
I think that from the outsider's perspective, and this is where Hollywood is probably not the best place to do my research before our interview, there is a common plot line of awful divorces where parents start using children as bargaining chips or to try and influence outcome. Is that something that you do see happen as regularly as you see it in Hollywood, or is it less frequent in terms of the practice day to day for you?
I think I would separate that out a little differently. In the way that I would is, this is a change in advocacy over the years. You know, the AAML had changed their bounds of advocacy from zealous advocate to really doing well for the family. I can't think of the language specifically, but what I see in custody are those people who my client says that, he was never home or she was never home. She worked all the time, and they're not going to now get time with the kid. They can have every other weekend, and that's enough. And that if that's what the client says that they want, the attorney is hired to do that. I don't take cases that I believe the result is inconsistent with the best interests of the child. And that's how I would more see the differentiation. I think we have, in general, a pretty great group of attorneys that I've seen throughout the state that really do focus and work to focus their client on what is in the child's best interest. Yes, the ugly ones, and I've had my share of ugly ones.
Do you find it to be a challenge, given how personal the consequences can be for a parent who may be tied to outcome as opposed to being open to outcome? Do you find that you run into any sort of challenges with boundaries between being, say, therapist and being counselor at law? And how do you sort that out when somebody starts perhaps being too needy in one regard?
In part, that's the who am I going to work well with. This may be digressing way too much, but when I started law school, my son was 3.5, And like the first week, I thought that if I try to study when he is awake, he might not survive my law school career. And so I established really good boundaries, very little sleep, but really good boundaries. I just did not study when he was awake. And when I opened up my own practice, I did the same thing. You know, he'd go to sleep at night and I'd be up till 2 or 3 in the morning working. Mediation was another one. It was a new field, but I'm dealing in a mediation with parents who have kids in really, really, really difficult situations and are desperate for help, and nice people from school districts who want to help and don't have the money. And I remember reaching the stage of having to tell myself over and over and over again, this is not my issue. The outcome is not, I can only do the best that I can. And I think that has carried me well into being able to get as close to a parent's pain as I can, but I see a big part of my work as needing to be objective, that it's up to me to tell that person, that's not going to work in court. That's not going to work for your kid's long time. And so I often say, you know, a therapist is a bit cheaper.
There is a phrase that I've come across, fortunately have not had to dive into myself, in terms of family law for me, and that is collaborative separation or collaborative family law. And my question for you is, have you come across this phrase? Is it something that you're familiar with? And doing kind of what I might call the high stakes, high end work that you do you have any feedback on its efficacy?
I was trained in collaborative law when it first came out, or when it first talked about early training.
Perhaps you could define it before we launch into it.
It is a process that is intended to be transparent, so that you've got 2 attorneys, 2 clients, and you meet as a group of 4. Often you meet with experts and coaches. It can involve a lot of people, but the idea is that you're not separated and coming up with what's best to hit the other person with and doing that kind of maneuvering in negotiations. Negotiations are to be transparent. After doing the training, as a process, I like mediation better for resolution. As a process, I like collaboration, but collaborative law, key to collaborative law, is if it doesn't work, then the parties need to start anew. The attorneys, they sign an agreement that the attorneys cannot take them into the next stage. So from my perspective, I get a lot of cases that fall out of collaborative law. I have seen it practiced. I have seen and talked to people who have lots of good things to say, but that's not what I see of the cases. And of the cases that I see, I wish, I look at them and say, oh, if you had only come 3 months sooner, we might have been able to go this different route for negotiation, and maybe we wouldn't be on a path that is leading us right to court. That's my perspective, which is limited by my experience. The other thing that is relevant to that discussion is, despite my insisting I would never be a trial attorney, I'm known as a litigator. And so a lot of my referrals come from other attorneys who don't want to take the case to trial and have decided they're not litigating anymore, and I get brought in at the end. So here I am as a trial attorney. I do that. I feel like I do that well, but I much prefer having a case from the beginning where chances are much higher that it's not going to be tried. Because if there's no kids, they end the divorce. It's no kids, a short-term marriage. There's not going to be a lot of ashes left in the path. But if it is a marriage with kids, these people are going to have to be dealing with each other. You used to think it was till 18, but no, then there's weddings and graduations and grandchildren. And do you really want to bring to your grandchildren the way the conflict was between you and your spouse? And so it has long-term consequences that I always am conscious of.
A friend of mine who was going through a separation described it as, I may no longer be married to this person, but I will be a co-parent with them forever. And that was the way in which he wanted to approach the separation, to make sure that it was done, while challenging, as to leave as much of the relationship not destroyed as possible.
Well, and I think that the reality is, my guess is a lot of people really are able to do that. Of course, the ones that we see in the courts, the ones that I see, are the ones which have the highest conflict and are likely to do the most damage.
Turning the spotlight back on you as far as that's concerned, why do you think it is that you have become kind of a go-to person, from not being a trial lawyer to being kind of the bright light that attracts some of these more challenging cases, the trial work?
Well, I think my experience, most family lawyers don't go to trial. And it's hard to get a trial. Maybe because I'm willing to do it.
Who dares wins. I'm going back to something you said earlier about the mediation process that you were originally trained in, which you described as Kissinger-style mediation, a shuttle diplomat moving back and forth between rooms. Is that how mediation is generally done in the family law environment, or is it done differently now?
It depends upon who you use. Sometimes I feel like in family law, it makes a difference whether or not you're having a settlement conference or a mediation. If you're having a mediation, all of the evidentiary code exceptions to any admission of evidence applies. If you're having a settlement conference, what happens in that settlement conference may be admissible. And that's because in family law, there is a provision for fees. Well, there's fees for need-based fees, even the playing field, the objective there. But there also is a statutory provision that provides fees based upon good behavior.
Who interprets that? The judge?
Yes. You generally would not do it until after the case is over. And then you would be presenting. I recently had a case where in the fees section, I presented a settlement proposal I made 6 months before the trial, in which the trial ended up with my client doing better. So I know there is the CCP section in other areas of the law, but that only covers costs. So 198, something, yeah, something, yes.
You're good. You're remembering so yeah, it's a 998 where the prevailing party can be entitled to expert costs, but there's no attorney's fee provision there.
Right. This provides attorney's fees and expert fees. And so bringing it back to mediation, your question on mediation, when I started it was the shuttle diplomacy, but now one of the leading mediation teachers is Gary Friedman in Marin County, and he conducts mediation with everybody in the room at the time. You're not afraid of conflict. And when I mediate, I do a little bit of both. I'd prefer having people together and dealing with the issues together, working on it together. But I have no objection to meeting separately.
That was part of what I found so interesting, because in our personal injury side, in the compare contrast that I've been doing today, the mediations typically are very much segregated. It's still shuttle diplomacy. And part of that is when you did, say, a joint caucus beginning where, the trial attorney got up and pounded on the table and demonstrated all the ways in which they were going to win if this case went to trial, the mediator's job was to spend the next 2 hours trying to calm both sides down.
Right.
And so I find, as somebody who ironically is conflict averse in the field that I'm in, it's part of why I think I like trial more than mediation, is that notion of being in the same room with someone and my emotions getting a rise.
There's different ways of mediating, and I think that a lot of the mediations that are done by some of the retired judges are done more on the risk-benefit analysis. And so having people in separate rooms and, let me tell you that if you don't agree, this is what it's going to cost. And that's part of the risk-benefit analysis, very similar to a judicial settlement conference. And the other mediation is more interest-based. Look, you've been together for 25 years. You've got 3 children. You don't have enough to create the same situation in 2 houses. But let's look outside of the box of what a court would order. And how can we, if we were to, the court in general cannot give one spouse the house to sell later. But in mediation, we can do that. So that's a big difference in the style of mediation.
And it sounds to me like that those deep roots of mediating early in your practice may have given you some insight into creative approaches.
I think that that's true. And I really like working with experts, whether they're mental health professionals or the paper toner expert or a financial account expert, a forensic expert there. And the idea would be that my expert, say my custody expert, there's another expert on the other side. Let's start talking. Let's meet. Let's brainstorm how to do this. I love that. And I do that when I have a forensic expert in the accounting field. I really encourage that person to work directly with the other side's expert and not involve me in all of those meetings. You can go through your QuickBooks and compare and ask questions of each other. And it's a very positive way of removing obstacles.
Switching gears a little bit, making sure we cover an area that certainly is of interest for me. On occasion, I've had a case where someone comes to me and in the pendency of the case says, the injury has been very significant. It's had an impact on my life. My spouse and I we're going to be separating. And obviously for me, that sends up red flags right away in terms of, okay, we've got a new potential legal issue that's impacting the case that I'm handling. What types of things would you recommend to a lawyer like me or injury lawyers when that surfaces in terms of how we can best advantage our client going forward?
If the injury occurred before separation, the damages are community property. However, the court it's an exception to the equal division. So in awarding the damages, if they separate before the damages are paid, or if they separate even afterwards, there's equity. Now this goes back to a while ago when I did some personal injury. What are the damages going to be for? Are they for future wages? Are they for pain and suffering? And if I remember, that could be a significant way in how the damages are structured.
Many of our cases, a catastrophic injury oftentimes has a future wage loss component. And it almost always there is a past medical expense and some form of past wage and some past pain and suffering. In catastrophics, there's usually future wage, future medical, future pain and suffering. And the challenge that I see us headed into is because most cases settle, I presume most cases settle in family law, even if you are a trial specialist. The challenge that I now am foreseeing is when we settle a case, it's a global settlement. It's not this much has been allocated for future wage, this much has been allocated for future pain and suffering. And it sounds to me like that might be something that comes up in a separation.
It very well could. It very well could. And it might be something that if we were talking about it before you got the settlement, I would be saying, well, if you were to go to a trial, what would you be putting out as lost wages? Let's think about that differentiation.
Interesting. Are there other things that come to mind in terms of worries that we might have when a client tips us off that there is an issue like this?
Well, I think that if there is a judgment against a party and it arose during marriage, then it potentially is a community debt, and the community property could be liable for it. If the judgment comes down after the judgment of divorce, I mean, that strategically could make a difference. So instead of the community property being liable for it, the parties get their divorce, judgment comes down or a decision to pay, and there's no more community property. So that's a timing issue that is worth considering. Not as a plaintiff's lawyer.
No, it's causing wheels to turn because that was not a piece that I had considered. And the first thing that comes to mind is anytime we see an asset maneuver on the defense side, there are times where it can truly be a life circumstances, this is what's happening. And there are situations where it can be a fraudulent transfer. And the question is, which is it, and does one have the ability to unwind something like that if that is a strategy that is being deployed?
We recently had a situation where the plaintiff's attorney in a civil case tried to join the divorce case regarding potential fraudulent transfer. And the court would not let them join, but it's still an issue.
Interesting. I think that's probably, as I think of, we talked a little bit about creativity. And that is one of the things that is interesting about whatever practice we have. We are limited only by our creativity and a little bit by the rules of civil procedure.
Yes.
And ethics, hopefully.
Absolutely.
We've talked about many different things so far. Can you tell us a little bit, and this is a tangent, but one that I'm interested in. Why is scuba diving a passion for you as a lawyer?
I'm sure it's not just being in family law, but as a family law attorney, it is an area of the law that is hard to separate, hard to leave. And when I am underwater, nothing comes in but the environment I am in, which reminds me of your saying about the trial work, that you're so in the moment. And that's what diving is for me. I am just so in the moment. The things that come into my head are music and, wanting to dance underwater, fly underwater, see these most incredibly beautiful things, and nothing else comes in.
That's wonderful.
It is.
We've had a wonderful conversation. Is there anything that we haven't touched on that you think it would be important for our listeners to know?
Yeah, there's one more thing that I'd like to mention. I've been very active in the academy, trying to diversify the family law bar. And I think that family law is and can be a wonderful opportunity for people to use skills to help people. There's no question about it. Use your legal skills to really advance the interests of your clients when they're dealing with the worst things. And in general, the family law bar is a very white bar. And so I've been working on this committee, and we set up a scholars program that we're bringing in law students to introduce them to family law and to introduce them to a cohort who could go through the next several years and perhaps help diversify the family law bar community.
For students who might be listening, and I know we've started to get kind of a cohort of students, and interestingly enough, UC Law is one of the areas where we have a lot of listeners. If there are students who are listening and interested in something like this, where would they go to get more information?
They can contact my office.
And if there is a website or other place, we can go ahead and put that in the show notes as well.
There is.
Wonderful. Thank you very much for being here, Lorie.
Thank you for having me.
And thank you for listening today. Please email us at podcast@coopers.law with questions, comments, feedback, and suggestions. Like what you've heard, share us with a colleague and leave us a 5-star review on Apple Podcasts. To all of you doing justice out there, happy hunting.